Thanks everyone, welcome back. We're going to kick off our third session today dealing with the Environmental Regulator when they come knocking. Our speaker is Kirston Gerathy. Kirston is a specialist planning and environmental lawyer and partner in our peer group here. She has a particular emphasis on strategic, regulatory and environmental aspects of both development and infrastructure projects. Kirston has particular experience advising clients in relation to biodiversity, threatened species, heritage conservation issues, regulatory and compliance regimes relating to the pollution of the environment. And as we all know, that's front of mind. She regularly advises in relation to large-scale infrastructure augmentation and has conducted a number of appeals and advised on policy relating to contaminated land. Kirston provides specialist advice on strategic decision for front-end planning and has a highly successful approach to conducting environmental litigation. Please welcome Kirston.
Thank you very much, Jenny. I'll endeavour not to simply direct my attention entirely to the camera, but also speak to those of you who are brave enough to attend. The topic was, of course, dealing with the Environmental Regulator when they come knocking. Now, one would hope in the course of the conduct of your businesses, you never have to deal with that circumstance. However, why is this particularly important? First of all, the fundamental proposition in relation to pollution incidents and management of contamination in New South Wales and indeed Australia-wide is the polluter pays. So if an environmental regulator comes knocking, there is costs exposure at all levels. First of all, costs of the clean-up action which you are going to be responsible for. Defending a prosecution is extremely costly. And thirdly, reputational damage is something companies are much more aware of. Brand management, risk management, particularly if you're a listed company, because many times one of the fines in inverted commas, for conviction for an environmental offence is take out a front page ad on the Sydney Morning Herald saying, I've been convicted of this as a company. Also important for you in your role as in-house counsel is to know that the corporate veil gets lifted quite readily in circumstances of environmental offences. Company directors and indeed managers can be held personally liable in a criminal sense as well for these types of offences, as well as the corporation. So how you and your employees deal with the environmental regulator throughout the course of an investigation, in my experience, is actually critical to how you are going to be dealt with in turn. Let's look at it. Who is the environmental regulator? This is merely a snapshot of them. There are many pieces of legislation and many organisations and authorities who have regulatory powers. Local governments are indeed one of them. Now, the purpose of today's discussion, we're not focusing necessarily on the regulation for, say, land use, which might be more relevant to some of your particular organisations. In other words, if you don't consider you're particularly at risk for a pollution incident or something like that, but that perhaps there might be something in relation to the conduct of your business, either not with development approval or otherwise, then you're going to be facing up to the local government authorities more likely than the EPA. So, as I said, it depends on the nature of your land use. Also, too, I understand that there are some local government in-house counsel who are participating in this Cram Day session. You don't escape. You yourselves may well be the subject of regulatory action in circumstances where many of you operate waste treatment plants, sewage treatment plants, or anything like that, which is prone to potentially be a polluting use. So, here is just a snapshot of pieces of legislation, and by no means comprehensive, which may give rise to regulatory action in response to activities of the corporations for which you are responsible. The paper today is going to focus particularly on the first Act, the Protection of the Environment Operations Act. We would be here for half a century if we went through all of the potential regulatory activities. It's taken me 26 years to get through them all, but we'll focus on this one in the first instance. Now, in relation to the Protection of the Environment Operations Act, colloquially known as the POEO Act, we're looking at things such as water pollution, noise pollution, air pollution and land pollution. And depending on what type of activity it is, the regulatory authority will be the Environmental Protection Authority or the local council. Other acts have different regulatory bodies. But we're talking about a pollution incident, and what is that? It's basically the escape, not necessarily escape from Alcatraz, but an incident or set of circumstances during or as a consequence of which there is or is likely to be a leak, spill or other escape or deposit of a substance as a result of which pollution has occurred. It can be an inert substance. So it might well be that the escaped substance actually doesn't damage the environment, but that doesn't mean that it doesn't fall within the definition of pollution incident. We're focusing today particularly on certain responsibilities that are imposed upon those, the corporation generally, and those within it in respect of pollution incidents. The reason we're doing that is if you fail to report a pollution incident posing potential material harm to the environment, you commit an offence, a criminal offence. So the company is liable for a criminal offence, and as we'll get to in a moment, those in actions or areas of control can also be held liable and prosecuted personally. So it's fairly serious, particularly as the maximum penalty is $2 million for a corporation, and $60,000 a day continuing, sorry, $120,000 a day continuing if you fail to report and you breach your obligation, and for $500,000 plus $60,000 a day for continuing offences for individuals. So we're not talking chicken feed, it's a fairly serious matter. And the obligations upon those within the organisation become relatively critical. The other reason it's important that we deal with the issue in relation to these things, and this is the overview of what we're going to deal with today. This slide is important, I think, because this is the concentration, effectively, of what we're going to be looking at today. The other reason why it's particularly important to understand your obligations in relation to reporting, that's self-reporting, is that it can attract special executive liability. Now, some of you might be familiar with certain regimes under the corporations legislation or the New South Wales directors legislation, which seeks to actually put at the veil between the directors and the corporation in terms of liability. It does so in circumstances where there aren't special provisions for special executive liability. There are for pollution incidents, special executive liability arises, and basically it is a presumed responsibility. So it's a strict liability offence, presumed responsibility. You are on the hook unless you can establish certain defences, which we'll come to in a moment. So in circumstances where the stakes are high, your interactions and your response to the regulator is pretty critical. The easiest way to get on the wrong side of the EPA, who has a series of prosecution guidelines, by the way, and one of them is, have you cooperated with us, is not to notify them, or when you do notify them, treat their activities as with disdain. For instance, these people are simply doing their job. It is a reflection of parliamentary intention that environmental offences have significant consequences. So calling them greenies, saying that's not water pollution or everybody does this whilst they're investigating your premises is probably not advisable. I think you should take a different approach. As I said, in the conduct of those who are being investigated is relevant to whether or not you're ultimately going to be prosecuted. So every interaction counts, and we'll get to some case law on some interactions which weren't so successful and let you know what happens. I did mention the special liability for executive executive liability. There's two levels. There is special executive liability for strict liability offences, and guess what? Failure to notify of a pollution incident is one of those ones. So there are other offences in the Protection of the Environment Operations Act which attract executive liability, but the onus is not there. The onus is reversed. The onus will be on the regulator to actually prove on the balance of probabilities the offence was committed by the individual, unlike the special executive liability responses where you're presumed to have done it unless you can establish a defence. So very, very high threshold, so they take notification seriously. Why notify? Well, the whole regime is based on polluter pays and also reflects the parliamentary intention about the seriousness of potential environmental incidences. So there is risk to environment, there is risk to public health and safety, all of which is bound up in this whole process by which you are to interact with the regulator. The EPA's view and the regulator's view is early notification enables them to direct appropriate action. So enables the regulator to turn up, to take photos of the incident, to direct you to do certain things, to mitigate the incident, and to prevent environmental damage from occurring. This means that they can make an initial assessment of the environmental damage and quickly direct activities. So it is important that you get your response right at first instance, and as we'll see shortly, important to have systems in place. Because there's not much point having an obligation to notify if nobody in the corporation knows they are in fact obliged to, and nobody in the organisation has a role who it is to notify. So who must notify? All of these people. So the person carrying on the activity can be a corporation, it can be an individual, it can be an employee. For instance, if you had, say, you were a chemical manufacturing process plant, you store chemicals in bins, you have an employee whose job it is to move the bins into the storage shed, bins are leaking, he doesn't think it's his job to notify anybody, so he doesn't. How does that actually pan out? Ultimately, there is no defence that there was no knowledge on behalf of the employee to notify the EPA and indeed his employer in respect of incidences, and simple things such as putting up signs in relation to notification would have been of assistance. Ideally, this who must notify would be dealt with in an internal policy. Depending on the size of your organisation and the activities that you undertake, you may have to have what is called a pollution incident response management plan, and try and make an acronym out of that you can say, I defy you. If you are carrying on a scheduled activity, and there's always lots of jargon in these types of things, a scheduled activity is something which is attached to Schedule 1 of the POEO Act. Usually these are the types of industries which have a higher propensity to be polluting. They can include abattoirs, they can include chemical batching plants, but interestingly they can also include marinas and things such as brewery distilleries, given the use of chemicals and the prevalence of gin, homemade gin that's going around at the moment anyway. If you don't have one of these management plans, and you're not required to have a management plan because you don't need an environmental protection licence, that's the threshold. If your activity is such that you need an environmental protection licence to operate, you must have a management plan. If you don't require a licence, then you should have an internal policy and procedure which identifies those who are responsible for notification of incidences and set out a program to do so. Even if you don't require a licence and you have a bit of a bad record, the EPA can actually direct you to have a management plan in any event. So it's quite a lot of activity. I keep saying notify. Well, who are you notifying? Who do you have to tell? Each relevant authority. Now, that can be relatively confusing, because how would you know who is the relevant authority? Well, in certain instances, if you are a scheduled activity where you have an environmental protection licence, the relevant authority will be the EPA. If you're a non-scheduled activity, the relevant authority might be your local government authority. But the appropriate relevant authority is defined in the Act, and effectively the EPA is the relevant authority for all scheduled types of activities, but the local government authority of your area is the relevant authority for those which are not scheduled. However, in circumstances where you have, say, an incident, what if the incident is ongoing? What if the incident poses a severe risk to health and safety? In other words, we have a chemical escape which is leaking down the street, running into stormwater drains, infecting the creek next door, and posing a hazard to our surrounding neighbours. What should be the first priority response of those who are identified in your management plan or within your internal policy to do? Is it, I best ring the EPA because this is happening, or I best ring New South Wales Fire, I best ring an ambulance because I've got workers that are sick and have been exposed, and I best ring the police because we need to shut down the street? It's all a matter of sensibility, and we'll get to some cases shortly in relation to how others have responded in circumstances where there were competing priorities and not enough people, to be frank. Not enough people who had the job to either notify or manage the incident, so one person was stuck and obviously couldn't possibly achieve everything that they were legally obliged to do. The EPA acknowledges that there are circumstances whereby you will need to prioritise your immediate safety response before you ring up the hotline. And that means take all steps to mitigate and minimise what's happening first. If the incident presents an immediate threat to human health or property, contact emergency services first, then contact your response agency. These are the types of things that ought to be set out in your firm's or your corporation's policies and be clearly understood. If you are particularly exposed to this type of incident, it's also something that we should review in terms of your annual review to policies. So we've covered who do we have to tell, what do we have to tell them. You can imagine you're under a lot of pressure. You're the responsible person trying to notify the regulator. Alarms are going off in the factory. You've got people running around and the police are outside trying to shut down the street, and half your workforce has been stretchered off, and this is a bit of an extreme example, being stretchered off in ambulances. What have you got to tell them? The Act actually prescribes the minimum amount of information that you must inform the regulator, which is set out there. So time, date, nature, duration and location. Nature, estimated quantity, volume and concentration of pollutants involved if known. Now this could be a bit hard if you are just watching a whole lot of yellow liquid seep out of pipe that's cracked and you're not very sure what it is or how much is coming out. In many instances, if you are the type of organisation which is prone to such incidences or is licensed, it may well be that there are fail-safes built in. In other words, valves or monitors or things like that will be there that will assist the informant in actually saying, okay, well, we estimate that 22 litres of hexavalent chromium leaked into the creek, and we can tell that because that's what our valve says. But you may not necessarily be in possession of this information. So this is the information that must be provided. In general terms, sufficient information must be provided to enable appropriate follow-up action. It's also a continuing obligation. When you notify, you may not know all these things yet because you might be having to do an internal investigation, or the information might simply not be to hand immediately. But the continuing obligation means that once you actually have this information, you must notify. You might be the recipient then, continue to notify, so to augment this information. Now, this is a bit of a kicker because this is actually what is the trigger for notification. Material harm to the environment that is caused or threatened. Harm to the environment is material if it involves actual or potential harm to the health or safety of human beings or to ecosystems. That is not trivial. I love these types of definitions because these are always subjective. We'll get to what's not trivial in a minute. It results in actual or potential loss or property damage of an amount in aggregate exceeding $10,000. Now, this is the person who's got the obligation to notify, either under your policy or under your management plan. They have to form the subjective view, one way or another. Must I report? I must report if these circumstances exist. Now, we'll get to harm that's not trivial in a moment, but the second threshold test, to give you a bit of a hint, it also, to quantify this, loss includes reasonable costs and expenses that would be incurred in taking all reasonable and practicable measures to prevent, mitigate or make good the harm to the environment. And it doesn't matter that the harm is only on your premises. You don't need to be harming anybody else. You don't need to be harming a natural resource. If there is a clean-up cost, of more than $10,000, you're triggered. Now, how do you know this? Instantly. I mean, the person whose duty to report is, oh, I'm eyeballing that, I reckon that's going to cost us about $5,000 to fix, don't you think? Or, oh my God, I don't know, this could be $100,000. No idea. This is a difficult threshold, and it is subjective, and there has been one successfully defended case, which we'll come to in a moment, whereby the Bulga coal mines directors were found not guilty of the failure to notify because they didn't have this subjective opinion as to cost. Trivial harm, regrettably, this is very, very difficult. It's always a question of fact and degree. But the threshold of trivial is not high. In other words, err on the side of caution in relation to triviality, because you wouldn't want to be making a poor call on the basis of, oh, I didn't think it was material, I just thought it wasn't very much, given the strict liability nature of the offence. All right. Now, Orica. Orica is not exactly a stellar example of an environmentally responsible citizen. They have a bit of a criminal history for environmental offences, and they were also the reason that the POEO Act was changed on the duty to notify. I'll get to the instances of the case itself momentarily. Before the prosecution was commenced against Orica for an incident which involved, they have a ammonia plant in the Kooragang Island, and the ammonia plant is obviously highly likely, or without appropriate risk management, it's one of those high-risk type ventures. They did have an environmental protection licence, and they also had in place management plans and policies and a permanent environmental manager, given the nature of the activity. What happened though was that in the production of ammonia, there was obviously a bunch of potential off condensates and off products, and one of those was hexavalent chromium. Hexavalent chromium is known to be a pollutant and known to be harmful to human health. So I'll get into the guts of it in a minute, but before Orica's, it was actually the 7th offence that they were prosecuted for that year, but never mind. Before this prosecution commenced, the relevant time to notify a pollution incident was defined as soon as practicable. It now is immediately. So immediately, obviously, has some connotations. We'll get to what it means, but it used to, in other words, they did change the test. So what happened to Orica? Orica's producing its ammonia. Orica has a program whereby it shuts down its ammonia plant every 5 years for maintenance. It's quite a regulated process, and then it starts it up again. In this instance, the ammonia plant went through its shutdown. They started it back up in accordance with their process, and about 5:40 p.m. on the 8th of August 2011, the alarms start going off. And at 6:05, residents around Stockton, up in Newcastle, started ringing up saying, there's yellow rain falling from the sky, and it's on my car. So a number of actions were taken. The plant managers went into force. They shut down the plant. They put in place other activities to try and regulate what's happening, and they did an internal investigation and discovered and formed the view that condensate was actually leaking on their premises, but they didn't bother checking the stack. So ventilation stack. So it obviously had escape paths, which were more than one. So there could have been condensate leaking from the actual plant itself, but also too, part of ammonia processes that uses a lot of steam. So by 8:30 p.m, and they've run around and shut the plant, they finally decide to notify the internal occupational health and environmental safety person. Her name was Ms. Woodruff, and she was a very experienced person. She had about 18 years experience as an environmental manager of these types of activities. At 10 p.m, Ms. Woodruff gets a call from the chemist employed by Orica, who says, oh yes, that's right, it is hexavalent chromium in the samples. And at this point, after she was prosecuted, she realised that she should have notified the EPA. What her first priority was, however, was not notification but mitigation. to try and put in place actions and activities that would prevent further off-site release of hexavalent chromium. So she finally turns up to the site at 10:40 p.m, works through the night, doesn't go to bed because it's an extremely serious incident, and at 9:50 a.m. she gets another call from some residents who say there's still yellow rain falling on my car. At this point she goes, I think I should notify the EPA of this incident, a relatively serious incident. And at the time, the test was as soon as practicable, not immediately. So the EPA prosecuted Orica internally the two officers who were responsible. They alleged that the failure to notify, which then was as soon as practicable, but incidentally, the test, they actually amended the legislation because they realised that they were going to be in trouble with as soon as practicable, and it became immediately in January 2012. So this prosecution was started in November 2011, and by February the test became immediately. Anyway, what the EPA said was the failure to notify from 6:30 p.m. when they first found out about the incident, or 5:40 when the alarm started going off, till 10:50 the next morning was both willful and intentional. There was a failure of the manager to inform the Environmental Health and Safety Manager, and there was a failure by her then to notify the EPA, and she didn't do it till the next day. Well, the court held on the evidence, including the fact that Ms Woodruff's priorities were trying to actually mitigate, and she had been working all night, it wasn't a willful or intentional failure, but it was negligent. It held that Orica was simply not aware of its environmental responsibility and legal reporting requirements. It wasn't aware of its own environmental management plans and policies, and it displayed significant incompetence, and it was a serious breach. And Orica was fined a significant amount, totalling $211,000 for the incident, 36 of which was the failure to notify, which was discounted. What's important to note, Orica had spent hundreds of thousands of dollars in any event on clean-up action. It had been out in the community, it had been out addressing the 452 houses, I think, it offered to clean. It did a whole lot of sampling around the whole suburb of Stockton, and it was ultimately found that about 40 grams of hexavalent chromium had been released, which didn't pose a significant threat, but they didn't know that until they'd done the sampling. It also argued that this cost ought to be taken into account on mitigation and penalty, and the court said no. You're a large corporation, polluter pays. You're responsible for your pollution, you're also going to get fined for not knowing what your own management policies are. So what it highlights is that even in large organisations that should be well on top of their processes, the failure to engage with employees, no point having a lovely policy in the bottom drawer of somebody's desk unless it's actually able to be complied with. And this is something, I suppose, as in-house counsel, it will be your role to make sure that your policies are both up-to-date, reviewed, responsive and complied with. Now, I did mention the test before of what is material harm, and we looked at the don't be trivial, and it is already ticked over if the clean-up costs or the remediation costs will be $10,000, which is a bit hard to eyeball. This has a mental element to it. So unlike so there's not a subjectivity, there is a subjectivity to this particular element. Bulga coal mine, which is up near Boak, Singleton Way, obviously coal mine, it undertakes mining activities and it washes coal, and it therefore has big tailing dams where the coal tailings sit. And those dams obviously contain elements which, if they escape, could be pollutants. On this occasion, the dam had a T-pipe in it which cracked. The dam was also in very close proximity to the 9 Mile Creek. 9 Mile Creek is what's known as an ephemeral creek, or if you're in the drought, a creek dry bed. So on this occasion, the T-junction had been inspected on one day. The next day, the employee whose job it was to do the walk around and check these things, noticed tailings in the dam bed because there was no water in the dam at the time. At that point, didn't think to notify the EPA because didn't form the view subjectively that there was material harm to the environment. Did notify his employer. The next day, those responsible did, and including their legal advisors, did another walk around. And the thing that triggered the EPA's prosecution, unsuccessful I must say, was that they then looked at how they were going to clean it up. How are they going to get these tailings out of the dry creek bed? Because obviously you can't leave them in the environment, particularly if the environment starts to fill with water and there's a further pollution risk. The only way they could do it was with sucker trucks. Big trucks suck it out like that, and then they went to find out how much a sucker truck would cost them, and they went, oh, that's a bit more than $10,000. Material harm threshold. In fact, the clean-up costs were $193,000 external, so for the sucker trucks and everybody else, and $94,000 internally. However, when the EPA prosecuted them, the threshold for proving that those responsible knew at the time that they did end up, sorry, I should go back one step. Once they worked out it was going to cost them more than 10 grand, then they notified the EPA because they said, we have hit the material threshold, so material harm threshold, and we're notifying you. But that wasn't until the next morning after they'd done their second walk around and rung up someone and said, how much is a sucker truck? So that was the basis of the prosecution, that it wasn't notified immediately. But the defence was the subjective opinion of those persons which had to be formed, that the EPA could not prove that they'd formed the view at that time. In other words, at the time they found out about the incident immediately, was that it was material harm. Here's what was held, strictly speaking. There was no evidence that any other person whose state of mind properly attributable to the company formed the belief or perception on the date the incident occurred was one which caused or threatened material harm to the environment. So there is still a mental element ultimately in this aspect, and unfortunately there is, this is the very first case of a defended failure to notify offence, and that's interesting because the failure to notify offence has been in the Act since 1997, so it's not new, it's been around for a long time, so it's the first and only case that dealt with the issue of mental element for subjective opinion, for is there material harm. Practical tips. As I said, although the Act says now the duty to notify is immediately, the EPA has acknowledged in its own fact sheets, and I don't know whether how forceful that's going to be as a defence if you waive the fact sheet at the prosecutor when they come after you, that taking immediate steps to prevent harm or to persons and property is a first priority. In other words, shut down the operations, make sure your people are safe, do whatever you need to do by notifying other authorities, as I talked about before. But what my opinion and my recommendation might be is all of these tips ought to be taken into account. If you're a large enough organisation, consider splitting roles. If you have a management plan, the management plan might have a split role between who is responsible for EPA notification, who is responsible for occupational health and safety, because you could be in incidences like Miss Woodruff in the Orica event, who was doing her very best, I think, doing her very best to control a situation without sleep and prioritising activities which she thought were the most important at the time, but ultimately getting prosecuted for failure to notify. So depending on the scale of your organisation, it might be worthwhile considering having a dual role so that you can implement these types of things in the case of particular incidences. So after you've had an incident and you've notified the EPA, what can they do to you? Quite a lot, actually. The EPA and other regulatory authorities have significant powers for investigation. My emphasis in speaking to you about this is your interactions with the regulatory authority are particularly important because your cooperation is a relevant factor as to whether or not they decide to prosecute you, is also a relevant factor that if you are prosecuted, that goes to sentence. You get a discount for being good people. So there has to be a balance between cooperating with the regulatory authority and also to protecting the interests of your corporation, because this is a potentially large exposure. What can they do? They can enter into your premises. I'll get to residential premises in a moment. It's probably less relevant, but you do need a search warrant to enter into residential premises. But company, non-residential, industrial premises, corporate premises, they don't need a search warrant. They've got powers of entry. Their powers of entry are pretty broad. They can knock down doors. They can disable alarms. They can do all sorts of things. They might have to pay you back if you damage some things, but locking the door is not A, not very cooperative, and B, not going to stop them anyway. They have these powers of entry. They can they can take samples. So they can go around your premises and collect samples. They can take photographs and videos. They can direct individuals to answer questions. Now, it's an offence not to. So if you're directed to answer a question by the regulatory officer, then if you decline on the basis of self-incrimination or incrimination of the corporation, you have committed another offence. However, you must of course be given, if you're being interviewed, like anything which potentially gives rise to a criminal prosecution, you must be given a warning in the usual fashion that any evidence you give may be used against you. If you answer in respect of a compulsory notice to respond, and I should have said this about the duty to notify as well, notification of itself is not admissible against you or the company in any proceedings, the fact that you've notified it, because you had a statutory obligation to do it, but any evidence that's gathered following the notification may well be. So the same thing happens with investigation notices and otherwise. There are certain protections for responding to a compulsory notice to either produce documents or to answer questions under the Act, because they will recognise that they're compulsory. This is interesting. Once on site, the relevant officer has quite extensive powers. They can do pretty much anything that, in the opinion of that officer, is necessary for the purposes of the investigation. They can knock off your car. They can steal your aircraft if you happen to have one sitting in your backyard of your corporation. They can inspect records. They can take computers. They can take phones. They have extremely broad powers. As I said, if they knock down your doors or cause damage, you can get compensation, but that might take a while. You can also if they're heading down the prosecution pathway, they will likely issue you with formal notices to attend an interview at a certain time and place, at which time you can be legally represented, but you are obliged to attend. Again, it's an offence. Seizing of cars or taking of documents and objects. This is one example I can give you of that. I don't know whether, I love the name of the case. The actual defendant was a fellow called Mr. Foxman. Mr. Foxman had a very large business in whereby he took, using his own vehicles, contaminated waste and dumped it out in the Wallandilly local government area without any waste protection licence. He dumped it, so much of it, that they took aerial photos of this stuff, and the clean-up costs were extraordinary. They seized his vehicles in the course of that investigation, and Mr. Foxman was one of those ones who was individually prosecuted and fined $250,000 for each offence. The reason for that was the prosecution proved that he was the directing mind of the company. There was nobody else making decisions on Foxman and Co. It was just him. So he bore the brunt of that fine himself. If you are a respondent to an investigation, it might be that you choose to undertake your own internal investigation. That could serve a couple of purposes. That could prepare you for any potential prosecution. It could also be as a way of demonstrating to the regulator that you are looking at your internal protocols and procedures and policies with a view to improvements. And these types of activities may well be facilitated by external lawyers. The reason you would limit internal communications is I think you just had a session on legal professional privilege for in-house counsel, and sometimes there are some difficulties on maintaining privilege in relation to internal communications when you have an in-house role. So, you need to be conscious of whether or not you've got a separated role, whether or not you have an individual practicing certificate, do you have a mixed legal or non-legal role, all those types of things I'm sure Mark addressed. The independence protocols, because if there is doubt about that, then internal communications in relation to the incident may well be discoverable because they're not covered by legal professional privilege. Now, for that reason, if it is part of your internal investigation to engage consultants to either advise you, to make recommendations as to mitigation, one way of putting the gap between between that information and the hands of the regulator may well be to engage external lawyers and get the consultants to be retained by them so that there can be some level of protection in respect of it. It needs to be set up correctly at the start, so it's worthwhile undertaking an exercise at the beginning, a bit of a triage, depending on the seriousness of the offence with your external advisors as to whether or not this needs to be put in place. So consultants' reports should be prepared for your lawyers. Consultants' reports should be prepared for the dominant purpose. We've all been talking about dominant purpose, I'm sure, for the last session, of seeking legal advice. So the relevant purpose of the communication is, of course, a question of fact, but be careful about maintaining confidentiality and be very careful about waiver, because in these types of incidences there's obviously going to be a number of persons that may need to be involved in an investigation depending on levels of hierarchy, people on the floor of the factory, people in management positions, people who are responsible for OH&S. All of these can be necessary in an internal investigation, but those chains of communication may well be discoverable and not covered. Responding to formal notices. Putting it in the bin and saying, I'm not going to answer you, bugger off, not the way to go. As I've emphasised earlier, cooperation with the regulatory authority balanced with maintaining a need to protect your company's interests with the benefit of either your advice or external advice must be undertaken. It's also extremely relevant to whether or not they decide to prosecute you in the first place, and also relevant, again, as I keep emphasising, to potential penalty if you have cooperated. Sometimes a formal notice will require the provision of a lot of information or require you or whoever else is responsible in your organisation to do quite a bit of digging. So usually the deadlines can be quite short. They might say give it to us in 14 days or give it to us in 21 days or something like that. That might not be feasible. So in my experience, if you respond and say, we're collating this information in order to respond to your notice, I will need till X, don't be afraid to do that. In my experience, provided you give a reasonable response and you don't wait till the expiry or the day before the expiry to say, oh, I need another month, you will be given an extension. The reason you want to get an extension is if you don't comply, that's also an offence. So making sure that you're on top of the game there and giving a realistic time frame as to when you might be able to provide the information is something you should get on the front foot with. Do respond to the questions. I've seen, because sometimes they ask for documents and sometimes they ask a series of questions. Goodness gracious, sorry about that. Just saying here's a bunch of paper is not sufficient, because then you will be deemed not to have responded to the notice, again putting you in the potential grounds of committing an offence. Very important, have a point of contact in your organisation. What you want to do is to control the appropriate flow of information to the regulatory authority. You don't want it coming from all angles, because you don't necessarily know what is being said. Your left hand doesn't know what right hand's doing, all of which might be admissible against the corporation. And bear in mind, you don't need to, when I say cooperate, you don't need to tell them more than what they're asking. You don't need to go over the top, but you do need to respond directly to the questions. Don't forget, if they are sending a notice to you, they might be sending a notice to a parcel of land that has been contaminated potentially by your activity, or potentially sending a notice to one of your contractors who might have been involved in the incident or is aware of the incident, and they will be looking for inconsistencies between everybody's responses. So it might be that you need to actually coordinate the responses between contractors, neighbours and otherwise. Keep in mind the EP&A prosecution guidelines, and I'll just let you know what they are. Pretty picture, doesn't help you very much, but when responding, the EPA is to notices and to requirements to attend for interview, the EPA has published guidelines for prosecution. And the EPA does not have unlimited resources. It does not prosecute every potential pollution incident or environmental offence, but it certainly has a well-publicised policy document which prioritises when they're going to actually use their regulatory powers. Factors which alone or in conjunction might influence whether or not they're going to prosecute you include the seriousness or the technical nature of the offence, the harm or the potential harm to the environment, mitigating or aggravating circumstances, i.e. didn't know about it or someone deliberately, like the fellow who deliberately declined to empty his sewer from his caravan park because he didn't want to pay sewage fees, but he did pay for a pipe to be constructed into the river, which then contaminated all the oysters for the next 6 months. He in fact was the first person that got jailed for an environmental offence. So that was a deliberate action. He materially gained by not complying with by the requirement to dispose of the, obviously, camping ground, caravan park, not sewage. So built pipe straight into the river, polluted everybody's oysters. That's Barclay Oysters case. So that was certainly harmful and certainly willful. The degree of culpability, the antecedents of the alleged offender. If you don't have a brilliant environmental criminal record like Orica did not, the likelihood of being prosecuted is higher because you have demonstrated basically disregard for the environmental laws. It's also taken into account, obviously, like any criminal offence, in penalty. So that's another thing. The likelihood of in the event of a finding of guilt, that's something that they internally do. In other words, have they got enough evidence on you? And is it probative and are they going to get up? Importantly, as I keep emphasising, this is a factor as to whether or not they're going to prosecute you. Whether the alleged offender acted in accordance with EPA advice or advice from another government agency. So for instance, ring the EPA says, oh, don't bother calling us, make sure you've turned all the taps off and make sure you shut down the plant and you better ring the ambulance first. And you've got evidence of that, and whether or not the alleged offender is willing to cooperate or has cooperated with the investigation or prosecution. So these are all relevant. Consequences of an interview and of a potential investigation. Ultimately, at the end of the day, the EPA or the relevant regulatory authority may decide not to do anything to you. They may say, yes, that was a pollution incident, but you cooperated with us. The actual harm to the environment is minimal because we've done our investigation and our sampling. Plus, you have been a good corporate citizen and you've taken a lot of action to try and clean up what you did. We see you're doing a great job, you've reviewed your internal policies and you have come up with a mitigation program which ensures that the prospects of this ever occurring again are significantly reduced. Good on you, no action. Or all of that, this was a bit serious, so we give you a formal warning. They can also give you a penalty notice, which is a fine, much like you might get if you throw your cigarette butt out. It's not of the same ilk, but if you know what I mean, a penalty infringement notice, which is basically a fine. The other option that they can use is what's called an enforceable undertaking. Now, this arises in the context of the commencement of a prosecution. Instead of going towards trying to have you fined, because obviously the receipt of a fine doesn't mitigate the damage to the environment. So, you might get fined, but the environment might not get fixed. An enforceable undertaking can be imposed in conjunction with or in lieu of a fine, and that is, and it is something that an offender can offer or can be the subject of in terms of penalty prior to getting convicted. And that might be, I undertake to do this activity. That could be either clean up the action of, clean up the works, the incident itself, or do something else that has an environmental benefit, which might be, I recommit to the recreation of a wetland on the edge of the creek which I polluted, plus clean up the creek. So instead of fining me, we're going to do something which is actually positive for the environment. So that's an option. And then there is criminal prosecution, which we've talked about, which has the potential exposure to what are hefty fines. $2 million and a continuing offence for a corporation, and $500,000 and a continuing offence for an individual is not chicken feed. The key message I have here ultimately is, in your roles as in-house counsel, don't ignore what is potentially a responsibility of a corporation towards the environment. If you have policies, you should review them. Those policies should be very, very clear and engage with your, as I said, there's absolutely no point having a policy sitting in somebody's drawer, because waving that around as a defence is not going to help you. Those policies should be ones which are engaged with your workforce. If you have an EPL licence as a necessary consequence of the conduct of your business, you must have a pollution incident management plan. You should clearly define the responsibilities of notification and reporting. Consider split responsibilities if your organisation is large and the potential for incidences might mean, for instance, like poor Ms Woodruff, who's trying to do her very best to mitigate the incident, but ultimately the responsibility for notification also fell on her, and she was trying to do too many things at once. And subsequently, if you require assistance in understanding, and if you are the recipient, if there is an incident and you're the recipient of an investigation, put in place procedures and protocols to both cooperate with the regulatory authority, because it's going to do you good in the long run, but also to separately consider the protection of the corporate interests and those within it, potentially by engaging with external legal advisors in the manner I discussed before. That's all from me today. I hope that it hasn't put the fear of doom and gloom in all of you in relation to your potential for the pollution incidents. But if there's any questions, I'm happy to answer them. Otherwise, Jenny's here and ready to kick on.